Well, we've had a number of important Supreme Court rulings handed down over the last few days. The justices always save the most important or precedent-setting cases for last. And so they've released both the decision that kills off the Chevron doctrine and the decision that defines presidential immunity within the last few days. Joining me to talk about them, and a lot of the misinformation swirling around them, is Rick Esenberg, founder and president of the Wisconsin Institute for Law and Liberty. He created Will toward the tail end of a career in which he had taught constitutional law at Marquette University for many, many years. So this Constitution stuff is literally what he does and has done for decades. Good morning, sir. How are you?
Good morning. How are you, Jay?
I'm doing well. Let's start with presidential immunity ruling because there's a lot of misinformation surrounding it, given how Democrat leaders and activists leapt to insist that this ruling turns a president into a king. But I also don't fully understand where they drew this line. So what does this decision say?
Well, what the decision says is that it rejects Trump's claim that a president has absolute immunity for anything he does during his time as president, a claim that his lawyer really backed away from at oral argument. What the court says is that a president has, and it does use the term absolute immunity, for anything, any official act within his or her exclusive responsibilities. And the example it uses in the Smith prosecution is Trump's conversations with a member of the Department of Justice. I think he may have been acting attorney general by that point, Clark, in which he talks about investigating or, depending upon how you want to characterize it, encouraging claims of election fraud in the states. And the court says, well, look, deciding what crimes to investigate is within the president's exclusive powers to manage the Justice Department. It's just got absolute immunity. And then it goes on to say that some of these other things that are included in the Smith indictment, like, encouraging people to have alternate slates of electors or, talking to state election officials about, gee, isn't there some fraud there? That those things are a little bit more unclear. And the lower court has to ask itself, would permitting a prosecution here unduly interfere with the president's exercise of executive power? And the court says we can't decide that because we're a reviewing court. We are not a court of first resort. And since these things weren't examined by the lower court in light of the standard that we set today, it needs to go back. They need to do more work in order to determine whether the prosecution can proceed in those areas.
So it does leave room for prosecuting a president based on a case-by-case basis what the situation is.
It does. Basically, if you can characterize what the president did as an unofficial act or maybe even an act that is within the president's powers but is shared with another branch of government, or it's all a little bit vague, and there isn't a great deal of clear direction to Judge Chutkan on remand as to exactly what she's going to do, and I think for that reason there won't be a prosecution or there won't be a trial prior to the election because there's simply too much work to do on this question of immunity, and that itself is going to have to be reviewed by the court, and that just ain't happening in the next 5 months.
As a decades-long constitutional scholar yourself, what do you think of the decision? Good one, bad one? They missed on a few things. You think this was a good ruling?
I read something, and I can't remember who said it right before the decision came out, and the suggestion was, look, it's kind of a tragedy that we have to have this decision, because articulating a standard that would govern presidential immunity is going to be very, very difficult. And I think that the court found that it was. We can't do what the D.C. Circuit did and what the dissenters wanted to do in this case and say, well, anytime the president does something that turns out to be illegal or that a prosecutor can convince a jury was illegal, then there's no immunity, because that means there's no impunity at all.
Mm-hmm.
And you have to have some degree of presidential immunity, or you run the risk of falling into this, scenario of competing lawfare. And, we really saw that in the debate where, both of these guys running for the presidency, for the most powerful office on earth, were sort of playing a game of insults. And so I'll throw you in jail. No, I'll throw you in jail. And we don't want that, right? That's not
right.
the way
so to knock down,
it's supposed to work.
To knock down claims that are swirling, this ruling does not put a president above the law. It does not mean he could murder his opponents and get away with it, whether he uses SEAL Team 6 or a hitman, right?
I don't think it does. I think that you can look at any standard and find the reductio ad absurdum application of it. I don't think there's any court in the world that would say that. I think that they would come to the conclusion that that was an unofficial act.
Well, here's an example I'll spring on you. Does this ruling mean that Richard Nixon was immune from prosecution on his Watergate crimes? No, right? Because he ordered a break-in for purely political reasons?
Right. I don't think ordering a break-in. It kind of depends on what level of abstraction you describe what the president does, but I think the court would look at that and use common sense to say, look, ordering break-ins are not against political opponents are not an official act of the presidency. and I think the court signaled that was going to happen by sending the case back to Judge Chutkan, because of course a president can talk to his vice president about what's going to happen on the floor of the Senate. But so you could argue that that's within the president's responsibilities. It's an official act, but yet the court clearly suggested that it might not be an official act, depending upon the facts and circumstances of the situation, and came to the same conclusion with other aspects of the Smith indictment.
So I hear you saying that this decision is far less clear-cut and far more limiting than the Democrats are suggesting.
People are coming out and saying that this makes the president a king. It does not.
Okay.
And I think it would have been better, but it wasn't an option for the court. But it would have been better if this whole thing had never happened. If Smith had used, if the Department of Justice had used the kind of restraint that, had sort of governed, the Republic for like almost 250 years, and say, look, you don't charge your opponent in a political race with a crime unless you've got something really, really clear and really, really bad. And yes, I know people say that this was, isn't an insurrection bad? But of course, Trump wasn't charged with an insurrection, because that's a particular thing, and Smith knew that he couldn't make that step.
Yeah, that's a good point. It would have been better if none of that had ever happened that got us to this point.
It would have been, but it did. So
yeah, it did. So let's shift to the Chevron decision, which the activist left is also misrepresenting. Please explain why their claim that, now judges will be deciding what regulations Americans need to live under instead of scientists or experts. Why is that baloney?
Well, I think it helps if you start with a distinction which is very fundamental to lawyers. It's not an easy one, but it's a basic one, and that is questions of fact and questions of law. And what the Chevron doctrine said is that when there is a disputed question of law, in typically this would be a dispute as to whether or not an agency has been granted authority by Congress to do a particular thing. That's a question of law. That's a question of construing the statute. Chevron said, defer to the agency's interpretation of the statute. Defer to the agency's legal claim, not technical claim, legal claim as to its own scope of authority. And the court did that for a long time. It more or less abandoned that in a class of cases that are called major questions. It did that maybe 7 or 8 years ago. The world didn't stop. And what it did on Friday, it says, look, we're not going to defer to administrative agencies on questions of law at all. I mean, we'll give due weight to their opinion. We'll listen to what they say. If a technical question, bears on it, we'll take what they say very, very seriously. But, this isn't the resolution of a technical question. This is the resolution of a legal question. Yeah. And courts are the institution that the Constitution places that responsibility with. So this is a defense of the separation of powers. And it's a good thing because it's courts, not bureaucrats or
Right.
agencies or technicians that have the special expertise in construing ambiguous statutes.
We're talking to Rick Esenberg, constitutional scholar. Well, I tweeted yesterday something to that effect. I said all the judges really need to be experts in is the law and the Constitution, because they're really only deciding if regulations that these agencies are trying to put into place on their own, without Congress, meet a legal or a constitutional muster. You reacted to that tweet by saying, well, that's mostly it. So what nuances did I miss?
Well, I mean, believe me, the nuances are like inside baseball lawyer stuff. There are legal questions that can be influenced by how you view technical questions, and so you might have to, if you're interpreting a standard under a statute, it might be informed by technical matters, and what will happen in that case is the agency will set forth its technical position. Its litigant, right, the litigant that is disputing what the agency has done will set forth its technical position, and it may affect the legal conclusion. But mostly, I think it's easy to see if you consider the following distinction. I saw somebody said, well, now the court is going to set how much mercury can be in water. We're going to have judges do that instead of scientists, and that's not the case. What Loper Bright really says is that courts are going to decide whether the agency is empowered to set limits on how much mercury can be in water. Right? That's a legal question. That's a question of construing the statute. And then if they do, well, then they get to do it.
Right.
And believe me, they will get deference, and it would be very, very difficult to overturn an agency determination. You're going to have a very strong technical case, and you have to have a very strong technical case in court. You have to have very strong technical experts who support it.
Yeah. This is a loaded question, obviously, but do the Democrats and activists who are attacking these decisions not understand that they protect Democrat presidents and Democrat citizens too? As someone put it on X, the headline on this decision yesterday on immunity could easily be, the Supreme Court protects Joe Biden from vindictive prosecution if Donald Trump wins in fall.
That's true in the immunity. That's true in the immunity case. It's true in the Chevron case too. The president controls. Part of the problem that happened with Chevron is you had the specter of agencies changing their position with respect to their authority, depending upon who was in the White House and who was in charge of that particular agency. And so, and a lot of people have said on X look at the debate on Thursday, and do you really want to give either one of those guys more executive power? Don't you want to have their power checked and balanced? And our founders certainly did, and that's why we have a system where the legislature makes the law, the executive executes the law, it administers it, and the judiciary decides disputes about what it means. Mm-hmm. And in this way, having different institutions involved in the process protects liberty. It promotes consensus. It makes it hard for a bare majority or even a minority to oppress everybody else. I think it's a step in the right direction.
Yeah, these are all good things. We're talking with Rick Esenberg. Do you find it, I wanted to ask you this question as well, do you find it as dangerous as I do to see today's elected Democrats engaging in an organized campaign to destroy the legitimacy of this Supreme Court? I mean, it's one thing for some clown like myself on the radio or for the average citizen to criticize court decision they don't like, much less a Supreme Court decision they don't like. But elected officials, I mean, doesn't our republic crumble if one side convinces their followers that these justices are enemies of the people?
Well, it undercuts the rule of law. It undercuts the three-way separation of powers that our framers bequeathed to us. Look, a lot of the criticism that you hear from people on the left that the Supreme Court did something that's illegitimate, it has nothing to do. You're not going to find a legal argument in there. you're going to say, gee, I wish that the policy situation was different. I wish that this agency had the authority that the court said it doesn't have. Well, the solution to that is to go to Congress and get them to confer that authority on the agency. It's not to undermine the court. It's not to make shortcuts. And the other thing I can tell you about it is that it's absolutely wrong. Most of the criticisms of the court that we see, that, it's this conservative monolith. I mean, first of all, they have come to some conclusions that were not the ones that conservatives wanted in a number of these cases. And if you look at the court, it's not a 6-3 monolith. Most observers are coming to the conclusion that this is really a 3-3 court. I mean, you have the 3 left progressive justices. You have, the 3 more conservative justices in Alito, Thomas, and Gorsuch, although I have to tell you, Gorsuch is very different than Alito and Thomas. So that's not even a monolithic block. And then you have kind of the 3 in the middle, who are the 3 justices. They were the justices that were most likely to be in the majority in the term that just concluded, Barrett, Kavanaugh, and Roberts. And, are they conservative? Yes, in a sense they are, but they're different than Alito, Thomas, and Gorsuch.
Well, and you can correct me if I'm wrong on this, but I think what most Americans don't know and will probably never hear is that out of the 60-some cases the Supreme Court heard this session, the majority of them were mixed opinions. They were some unanimous opinions in there. Only a small percentage actually ended up to be 6-3 along ideological lines. I mean,
well, look at even the Fitzgerald decision, which was a win for some people that had been charged with obstruction in the January 6th, out of the January 6th disturbances. Brown Jackson was in the majority. Barrett dissented. And, there are all sorts of examples like that.
Yep. I think your dogs want their breakfast, and I'm run out of time. So I'll thank you for being on. I really appreciate it this morning. It's always great fun having you on.
Thank you. Take care, Dave.
Constitutional scholar and founder of Will, Rick Esenberg.